We are families, we are caregivers, we are parents to children with disabilities and medical complexities. We are rarely familiar. We get together to learn, to relate, and to laugh a lot while we share each other's unique family experiences of raising the rarest of the rare. Our goal is to unite, inspire, educate, and empower people living a rarely familiar life. And we're so glad you're here.
Hi, welcome to Rarely Familiar. This is Tram, and I'm here with my friend Jen, where we dig into the realities of raising the rarest of the rare. Today, we're going to get familiar with the topic of guardianship, conservatorship, and least restrictive model. So I'm super excited to get to our guests. But first, let's check in. Jen, what's going on?
Wow, what's going on? I have to say a lot. I'm having one of those very busy weeks. I just got out of a workshop that I gave a presentation to my students. I work for a university and it's kind of a packed day, but I'm closing it out by going to a track meet. I'm bringing my Julian with me and his stroller, and we're going to watch my best friend's son race in the 100-meter dash. And so I'm kind of in this space of remembering that a year ago, I had a senior in high school, and now he's in college. And track was our life and missing that time just because
Yeah.
running is such a big part. So I'm excited to go to the track meet, and my son comes home from college next Thursday. So I'm super excited
Wow.
about that. So
I know the spring season brings a lot because also lurking, it's May and school for our kids gets out soon. And I was like, oh my gosh, they
I
get out the
know.
second week of June. So I don't know if I'm ready for it. But let's see here. So for me, I went on Monday to actually visit a school that's not in district. And Sadie's only in fourth grade. But in our lives, medical crises happen. And so I might miss the open tours that they have for the different schools in the area. And to just ease my anxiety, I actually am going a year early
Oh,
and
wow.
visiting the
Okay.
different schools because then it's just one less thing to worry about. So it was nice to go visit other schools and get perspective and to hear parents' perspectives. So I've learned a lot from our own podcast where we've had guests tell us, look at these things like the budgets for the schools. And so I've taken what we've learned on our podcast and used it in my life now. Well, today we have a big topic, so I want to get started on it. We're thrilled to have Joe Kukla on the podcast today. Joe is an attorney and a partner at Teal, Anderson, Kukla, and Gunderson in Edina. Joe's practice focuses on assets and estate planning, special needs trusts, guardianship, conservatorship, and less restrictive alternatives, housing and alternative living, and the eligibility for medical assistance, SSI, and other government programs, all with the goal of helping people with disabilities live their full and rewarding lives. He does many other things. You can go on his website to take a look. But for our listeners today, we're going to talk about a conservatorship and guardianship. Joe has been presenting on guardianship and conservatorship and the least restrictive model for PACER for the last 10 plus years. I met Joe a couple of years ago at a conference. I was actually presenting on the Changing Spaces campaign and the advocacy for adult-sized changing tables, and he presented afterwards, and I stayed to listen. And when Jen brought up, we got to do a topic about guardianship, I thought, oh my gosh, I have the perfect guest. So Joe, welcome to our podcast today and taking time out to talk to us.
Yeah,
Yes,
thank you, Trump.
welcome. Quite a
Thank
resume there. I'm very impressed. And you are definitely the person to educate us and enlighten us today. So thank you for being here. And I actually attended, right? It was a virtual presentation with Pacer, I don't know, 10 months ago or something. And I listened, I absorbed some, but then last night I put my ear pods in and I went on a walk and I listened to it all again with a different kind of, obviously we're doing the show today, but also I have a 16-year-old. And so it's getting real. Now I really need to absorb this. I really need to pay attention. There's so much to learn. And so one thing that jumped out last night when I was listening was that you have a 38-year-old brother. And so I thought that would be an interesting tie-in. Maybe you could share a little bit about the backstory of that and how he made an impact on you to bring you to where you are today, or if there was an influence or not.
Yeah, of course. Of course, it was a tremendous influence. My experience growing up with my younger brother, Jake. He is 8 years younger than me. And when Jake was 3 months old, he was diagnosed with cancer.
Mm.
And
Oh,
and the cancer diagnosis was neuroblastoma. And this was in the 80s. And so the treatment wasn't the same as it is today. And to make this very long story much shorter, I'll say that part of what Jake experienced after he was diagnosed was he had a brain tumor. And so the only way to eliminate that tumor was by radiation. And so what I recall, and my parents knew before the treatment, that it was going to result in permanent damage to his brain. But they, of course, had no choice. It was either that or the cancer was likely to end his life. And so
The lesser
that
of two
is,
evils.
and so that is sort of how I grew up in that environment. It was really my introduction to the world of people with disabilities. And so it was always something that was present in my life, but like most siblings, I didn't really have any understanding or appreciation of everything that my parents did for my brother. But then when he was approaching age 18, they had to start considering what they had to do legally in order to continue supporting him. And so at this time, I was in law school. And so I learned from my parents that they were pursuing guardianship and also that they were doing their estate plan with a trust. And so the two are related because as the oldest child, they informed me that I would be the successor guardian, that I would be their successor trustee. And up until that point, I was just older brother. And so what my parents did was they asked their attorney if he would be willing to talk to me about that and explain to me what those roles were. And their attorney's name was Bob Gunderson. And
Ah,
Bob was a wonderful human being and extremely prevalent in this world of special needs planning and was willing to take about 30 minutes out of his day to give me a call and just explain to me what this all meant and what was going on. And so because of my experience with Jake and having that conversation with Mr. Gunderson, I sort of started developing my own interest in this area of practice. And I started realizing that this might be a viable option as far as a career path. And so at that time, I knew a lot more about this area of practice. I was really involved with Jake with Special Olympics, with bowling. And so I started getting a lot more questions directly from parents and other family members about guardianship.
So like when you're at like the event, they come up and say, "Oh, by the way, can you tell me more about guardianship and whatever?" Oh,
Exactly,
interesting. Yeah.
exactly. Like a doctor and you're at a dinner,
Hmm.
everybody says, hey, I got this problem with my knee. Can
Yeah,
you?
look at this mole
yeah.
on my neck. Does it look unusual? So when you were in law school, were you heading in a different direction?
Honestly, I thought I was going to end up being some kind of a litigator. I enjoyed being in court, but this was simply a direction that I took. And so I'm glad that I did. It ended up being something that I think is a very rewarding practice for an attorney. You get the opportunity to make your clients happy.
Yeah, it's definitely a niche area because it isn't highly conflictual, and it's obviously so helpful to parents like us who are eventually going to reach this point where we need to tackle this. So, yeah,
Yeah.
very interesting. Love.
Yeah. And that's why when I met you at the conference, you stayed after and you were willing to answer questions. And there's a fine line of us taking advantage of you, but also using your expertise because we are just trying to grasp information in those conferences or webinars. One thing that I did want to say was that we're going to attach your PACER YouTube webinar where you actually walk through all the roles and duties of guardianship. And if someone really wants to get into the nuanced details, they can take your webinar and we'll put that in the show notes. But at a high level, could you just explain guardianship versus conservatorship and what, as a parent, do they need to know to just be dangerous enough or know when they need to plot something out in their lifeline?
Sure. At its very basic level, guardianship means having decision-making authority for the person. Conservatorship means having decision-making authority for assets and managing money. And so when we're talking about these two, guardianship, generally speaking, it's like making medical decisions, making sure that the person has a safe place to live, and taking care of their care, comfort, and maintenance needs. Whereas conservatorship is much more directed to fiduciary duties, managing bank accounts, managing property that a person owns, handling investment assets. So because of that, it's actually quite rare for us to do a conservatorship for a young adult, just because that person usually doesn't have assets of their own. There is nuance to this. Like, people will ask me, well, what about Social Security? What about SSI? What if they start earning income? And there are ways that you can manage assets on behalf of another person without having conservatorship.
So it's unusual, but it is possible that you could combine the two and be the guardian and the conservator for an individual.
That's correct.
Okay.
We do it for people that do have the assets. And this is a good example of using less restrictive alternatives, is we try to work ahead of time to negate the possibility or the requirement of having a conservatorship. And part of the reason is that if you are a conservator in the state of Minnesota, you are required to file annual accountings with the court, displaying exactly what you have done with the assets. Those accountings are subject to audit, which means that you are subject to court hearings to question certain things like actions that you have taken or about how you are managing credit accounts. You're under constant supervision. And so we do try to find alternatives to it if we can.
So when you talk about the least restrictive environment, like, how would you describe that? Because you talked about it in your webinar, and it sounds like that's something that we need to really be aware of. And I had never really heard about it before. So could you explain what that is?
Thank you. For you, Jen, and myself, Sadie has very severe cognitive intellectual disabilities. So I think we never had heard of it, but now the discussions are always about supported decision making as well as least restrictive. So if you could explain that, I think that makes the difference of what your child cognitively can do as well.
Yeah. Well, I think you guys should all understand that this has been a progression in the state of Minnesota and, quite frankly, the whole country over the past several decades. This is an evolution of how we see people with special needs in the community. Going back 50, 60 years ago, when people diagnosed with disabilities were institutionalized.
Right.
Then you absolutely needed guardianship because somebody had to be making decisions for that person. When my brother turned 18, my parents went for guardianship. Oftentimes, the court wouldn't bother with questioning the decision of the parents to pursue guardianship. It was very much a rubber stamp process because the court looked at it as, well, nobody's objecting to this petition, so why do we have to waste time, digging into whether this is actually appropriate or not? And so somebody like Bob Gunderson, who I mentioned before, he would do 5 or 6 guardianship hearings in a day, because he would just represent the parents. He'd go in front of the court and say, this is mom and dad, they want guardianship of their 18-year-old. And the judge would say, okay, and boom, that was it.
Okay.
But as we've evolved and the Olmstead Act sort of pushed us forward in a sense towards the idea of people with disabilities can still lead independent lives and have the capability of making decisions for themselves. And so the concept of looking at less restrictive alternatives has to do with, let's stop and pause and question whether guardianship is really necessary for a person. Because what guardianship means is you have a person who's legally an adult, right? Because we just have this line that we have to draw in the statutes that says at age 17 and 364 days, this person cannot make decisions for themselves. The next day, they make all decisions for themselves.
Right.
But what comes with that is you have also a legal responsibility for the decisions that you are making. And so the question about whether guardianship is appropriate has to include whether your 18-year-old has the capacity to take responsibility for their decisions as well. Not whether they're always going to make good decisions. Right? The law does not protect against poor decision making, but do they understand the ramifications of the decision that they are making regarding their own health care, regarding their own personal needs, entering into a contract, right? If they go to the mall and stop at a kiosk and buy a phone, do they understand what the terms of the contract mean? Or at the very least, can you say that they are capable of being responsible for making that decision? And so what we look at now in terms of less restrictive alternatives is when we have people consider, well, my child isn't quite ready to make decisions on their own, but I don't think that I should restrict them from being responsible, from going forward as an adult and learning from their mistakes or anything. So it is very tricky because you could argue that a very low percentage of 18-year-olds in general are ready for that responsibility.
Oh, yes, I know all about that. I have an 18-year-old. This is maybe a stupid question, but there's no such thing as a stupid question, right? Can you be a guardian over certain areas of their life, like housing, or is it a blanket responsibility in all aspects? Because I know you talked a little bit about the different categories of criteria. Do they meet this? Can they do this or that? So is that possible?
It is. And
Okay.
so the guardianship statute breaks down the powers, it isolates them, I suppose.
Okay.
And so what we are responsible for when we file a petition with the court is letting the court know which powers under the statute we are requesting for the guardians. And what that means is that if that power is granted, then the right of the individual to make independent decisions regarding that specific power is removed and given to the guardian. So what anybody petitioning for guardianship has to consider is, do you need absolute authority over this area of their life or over these decisions? Or is this something that your son or daughter or your family member can reasonably handle on their own? Now, it doesn't mean that you stop being mom or dad, or you still assist that person, but you have to sort of make that decision about, do I need absolute authority, or does this person just need some help in these areas? And then that translates to the petition, and we can ask a lot of times for a limited guardianship. Good examples of that within the context of the statute itself would be like, one of the powers of guardianship is taking responsibility for personal possessions. And it's a very sort of tricky thing to ask parents. If they need new shoes, are they going to be able to figure out how to go and purchase those shoes on their own? If their iPad breaks, do they know how to replace that? So if you have somebody who's a little bit higher functioning, the answer to those questions might be yes.
Got it.
Okay, that's good. That's helpful.
So,
That's very
and
interesting.
if we can take a step back, if you were advising a parent, what are some tips, tricks, or things they need to know? Jen said her child's 16, 18's going to come fast. What would you advise them to do? Would it be like listen to your webinar, go on your website? Like, where would you even start? And when do they need to start contacting a professional to help? And I think then that could tease into how you work through it with clients in that setting.
I think the first thing is considering your own child's capabilities, right? Because if your child is profoundly disabled, then the idea of guardianship is going to be something that's going to be required
Yeah.
for their protection, to make sure that their medical needs are being met, to make sure that they are getting support through the county and through Social Security. So in that case, you don't really have to put in a lot of thought. You just have to be prepared that there is a process to this. The court procedure is likely going to take about 3 months, but you should consider contacting an attorney maybe 6 months prior to the person's 18th birthday to have the conversation and get this process started so that there is no period of time between the person turning 18 and you receiving your authority from the court to manage and make decisions with the guardianship. You can't start it too early, though. So, Jen, with your child at 16 years old, if you were to file a petition right now, even if there's no question about the need for guardianship, the court would say this petition fails as a matter of law because this is still a minor child.
And this is an
There's no.
overeager parent.
Yes.
Yeah, that's good to know. So I have a little time. That's great. And, Trum and I can check off the box because Sadie and Julian are very much obviously going to need guardians. So that makes our life a little bit easier in one way for once. Okay, so what if a parent who's not as resourceful or on top of things and proactive, what if they go, oh my, what guardianship? And their child is,
18.
18 and a half and whatever. What do they do then? What happens to the child? I mean, is it just like a lapse period where hopefully nothing happens, so then it's not like a big deal, but if something happens, it's a big deal? Or do they become a guardian of the state or like,
Well, the fact of the matter is what you said before about you just kind of hope nothing happens. That's sort of the reality because the individual rights that are provided to a person at age 18, those are automatic. You don't just get to say, I'm the mom and have everything work out.
so I suppose that would be the point where a parent would realize, oh, wow, I have to do this because I was
Yeah.
just told of the barrier in front of me.
Sometimes that is the
Okay.
case, and we hope that there's no consequence to that, but sometimes that does happen. So we'd like everybody to be aware and start thinking about this. That's why we meet with people and discuss the less restrictive alternatives, discuss the statute and say, I know you were told that you need to have guardianship, but let's examine whether that's really necessary or not.
What if a parent says, I don't want to be guardian? Then what happens? I mean, does anyone ever say that?
That's an interesting one. Your hypothetical is that the person needs guardianship. There's no question
Right,
about that. But
right. And
mom
this is not
says, no,
me.
I
I'm
don't
not
want to do
saying
it.
me, but let's say I'm a parent that's just checked out and I don't have the ability and my son just turned 18. If there is a parent in whatever situation and they just don't think they can be a guardian, then what happens
Yeah.
to the person?
Well, so what you should understand is then the responsibility is yours to find an alternate because you can't just petition the court and say, okay, court, find us a guardian. As my son needs guardianship, but I don't want to do it. Well, the court won't take that responsibility. So that's where you can consider other family members, of course. You can consider professionals in that
Okay.
situation, but our pool of professionals is pretty limited. Not a lot of people are willing to do this kind of work.
Yeah. There was one point that I think that you do need to understand too is, so let's say my daughter Sadie is 18, I pass. I either put it in my will or my trust and I say, I've named my oldest brother the guardian. Does that automatically pass or does this person now need to file for guardianship as well?
That's a good question. And the answer is it does not automatically pass. What you are doing in your estate planning documents is you are nominating, you are not appointing. So anybody that is going to be the guardian has to petition the court. Because if you think about the full process, and this helps parents too kind of understand why they have to go to court, we're talking about removing a person's individual rights that they are granted by the Constitution to live life as they wish. we're telling the court that it's appropriate to remove this person's individual rights because of their incapacity. And if they had the responsibility of making these decisions, they could be vulnerable and they could be
Yeah.
exploited. So when you have somebody nominated by a will to be a successor guardian, the responsibility of the court is to reevaluate at that time whether guardianship is still appropriate, and then to determine whether this person is the most suitable guardian at that time.
Now,
Okay.
what does the process look like? So now you're 6 months out. I've contacted you. I come in. What does it look like from there? And who else is at the table? Do you need medical providers to provide reports? What does it look like in those meetings to get the process moving?
The initial meeting that we're going to have is we're going to have this discussion about the powers of guardianship.
Yeah.
And I'm going to ask, tell me about your daughter. Tell me
Yeah.
about your son. What's it like for them? And then let's go through each of these powers and determine, what do you think your son or daughter needs help with? And is this an absolute authority, or can we talk about something less restrictive? And so sometimes it is a very easy discussion, right? It's, my son is nonverbal, he's in a wheelchair, he will never understand any of this stuff. But sometimes it is very useful to have this discussion. So in that process, we've made a determination that we're going to go forward with guardianship. Now it's about gathering the information to file the petition. And in that petition, we are going to state to the court what the diagnosis of disability is and why this person cannot make decisions on their own. It's not required by statute, but the courts are in the habit and prefer to receive a doctor's statement about the diagnosis and long-term prognosis to really back up the statements that you are making in the petition.
So you have this petition and then you present it to a judge in person in court, or can it be via Zoom?
COVID changed a lot, and the courts took most of the procedural actions like this and put them on Zoom. And so it is far more convenient with Zoom. They're a lot more precise with the time of the hearing, and you can just pop on the screen like the three of us are doing right now, and boom, you're in court, right? The judge will be there wearing a robe.
Right.
There will be a court reporter. But the benefit of that is that we can handle these hearings a lot more efficiently. And if there's no objection to the petition, then basically the parents are just there to explain the situation and put some information on the record for the judge.
And they have the child with them, correct?
Most often, we can excuse the person from the hearing if necessary.
Okay.
So there will be an attorney appointed for the person. And because technically, and this is sort of a weird concept for parents to understand, technically you are in an adversarial position to your child.
Yeah. Yeah.
Because you are asking the court to take away their individual rights and give it to yourselves. And so the court will appoint an attorney. Technically speaking, the person subject to guardianship is responsible for those fees, is responsible for the court filing fees and all of the admin costs. So we can ask for relief when it comes to those. And so the court-appointed attorney will be paid by the county to represent your child. But primarily what they are doing is making sure that this person's rights are not being violated, that due process is being followed here. But if they find that the parents or the petitioners are a bit overzealous and asking for powers that may not be necessary, they'll raise that, maybe not as a formal objection, but they'll raise that concern and ask the court to consider.
Okay, that's so interesting because that's what I've been wanting to ask you, is that we present this petition of all the reasons, we've analyzed the individual and these are all the reasons why they need a guardian. So really dissecting everything. And I was wondering, well, what about the guardian? Are they also put under the lens of, are they appropriate? And so that's the
Absolutely.
role then of the court-appointed attorney. Okay, very interesting. So that comes to cost. So some people say, oh, it's covered by the county. So it sounds like the court-appointed, that would be recoverable by the county. But what could a parent expect to pay, like a ballpark figure, to go through this process?
If you hire an attorney to represent you and take you through this process, which I do encourage, if you don't know this process, it is difficult and it can be extremely frustrating to try and obtain the order from the court if you're not meeting all of the statutory requirements along the way. So you do want to have an attorney representing you as the petitioner. The cost is going to be entirely up to that attorney, right?
I'm just thinking ballpark figure because right now I could start putting money aside. If I have to come up with $10,000 in a year and a half versus $2,000, that's a big difference,
Yeah.
Okay.
I will tell you, our fixed rate fee falls in the range of $1,000 to $2,000 for the entire process.
Oh, okay.
And
That's very
Yeah.
manageable.
One thing I wanted to ask. So let's say you do it, the 18th birthday happens, you show up at court, guardianship has been granted. What does it look like after? Do we have to keep going back? What does it look like in terms of any obstacles, or how often do we have to go to court? What does it look like?
Because like or with the waiver, it's these annual reviews. You have to go through this whole process just to continue to prove that they're disabled. And in my case, my son will be disabled next year and the year after. And I understand it's checks and balances and all of that. So yeah, this is a good question because do we have to revisit guardianship?
the short answer is yes. And
Wow. Okay.
and you have to understand that when you are appointed as a guardian, and I fully understand this from the perspective of the parents, they're like, well, why do I have to do this? I'm mom. Why do you guys have to interfere? The reality is, this is an independent adult in our community. Court is responsible for the protection of that independent adult. The court has selected you as the mom to be their representative in the community and taking responsibility for this individual and making sure that they are protected. And so your responsibility is to report to the court that you are doing your job. And so they call this a personal well-being report. It's a filing that has to happen annually on the date of the court order for the guardianship. You are responsible for filling out this form that basically says, here's how Julian is doing, some basic stuff about what's happened in the last year. Here's how often we see each other, blah, blah. This is really important when you have a professional guardian, right? Because how else are we
Right.
going to keep tabs on them?
That makes sense.
Just real quick, the other check on this that people should be aware of is in 2020, new legislation was passed to modify the guardianship statute that says that any new guardianship for a person who's under the age of 30 at the time of the appointment of the guardian has a limited duration of 72 months. And so you will get a court order and you will get letters of guardianship that will say very clearly on them that this authority expires in 6 years. If you file a petition for guardianship and you say this person is always going to need a guardian, well, the court is limited by law to saying it's 72 months. And in context, if you think about this, it makes sense when we're talking about all of those people who, when they turn 18, maybe they're just a couple of years behind.
Right. Delayed. Yeah.
And it's another progression, and it's another to say, let's acknowledge that this person at age 24 might not have the same needs for protection as they did at 18.
Right. It's very person-centered and it totally makes sense.
Absolutely.
It doesn't matter what we have to do as much as is our child being protected. So,
And
okay.
so what that creates for you, Jen, is a requirement that when your child is approaching their 24th birthday, you have to consider this again, because the court will not just automatically continue the guardianship. We've talked about this a lot because the law was activated in 2020, and this is now 2026. And so we are approaching on August 1st this year our first set of
Oh,
and so we've been talking a lot about this with the judicial staff. What is going to be the procedure for, we've got mom and dad as the guardians, and we've got their son who is profoundly disabled. So how can we make this as easy as possible? And
mm,
what the court wants us to do is petition like we are filing for a successor guardianship. And so we're going to have to go through the process again, and we're going to have to say, this person still requires guardianship because of these reasons, and we are still the most suitable guardians. Please reissue our order. The good news is that if the court makes that finding now at age 24, there is no expiration date on that new order.
oh.
So that can continue indefinitely, and you don't have to do this every 6 years.
I mean, it's really insightful in the sense that I see both sides, right? Because as a parent, you want to raise your child to be as independent as possible. And so, with all of the things that are built in the system, whether it's a waiver to help your child get to that next level, and we're getting the supports and the transition programming, right? We want to get them as independent as possible. And if they have the ability to get there, that's what the courts want. And I think that's what every parent wants. In some cases, it's just not viable. So, it is another pain point to a degree, but I think it just puts in the right checks and balances because we don't want to take away rights so lightly. And I think that's what I'm learning from this discussion with you right now is that we need to do due diligence on both sides because it is a long process. And if I think about it on a funny note, like conservatorship, you always think of Britney Spears, right? That's how everybody knows conservatorship.
I just wanted to make one more point. Guardianship can be terminated at any time. Don't
Oh.
think just because the order is issued and it says this is 6 years or it lasts in the future. If the decision is made that guardianship is no longer necessary, we can file a petition asking for a termination of the guardianship.
Oh, okay.
And so that is something that is a really nice thing to do, right? I've
Yeah.
families treat it like a graduation ceremony.
Oh, interesting.
Yeah.
Yeah.
You are constantly able to consider whether this is necessary or not. And if progress is made by the person and they become more independent, you can tell the court that this is no longer necessary.
So I've read is if you pick a lawyer, do they have to be within the county that they practice, or can you do cases outside of your area? What is a recommendation of when we're trying to find a lawyer to work with?
Now that all of the hearings are on Zoom, we can handle the paperwork, the filings, the procedural requirements all by correspondence, and then we can appear in court on Zoom all over the state of Minnesota.
That's amazing.
And we don't have to raise our rates to do it either.
Yes, exactly.
That's
So,
amazing. Yeah, that helps so many more people too. So
yeah.
less barriers, right?
But don't discard your local attorney.
Right.
Yeah, no, shop
Yeah.
local.
Yeah.
Shop local. So I have a community of girlfriends, and 80% of us are divorced. And so they don't all have kids that need a guardian assigned to them. But hypothetically, if you are divorced and you're co-parenting, and maybe you're not in agreement with things, maybe you are, but do both of you need to apply for guardianship? And then how do you handle it if there's a high conflict co-parenting situation?
Certainly. I mean, a divorce is really challenging, right? And
Yes.
co-parenting is really challenging. And so this is just another aspect of it. I will try and keep this as concise as possible, but I think big picture, what you need to understand is that divorce happens in family court and guardianship happens in the probate court. And the probate court is not going to make the same determinations as a family court will. And the probate court will also not take action that is contradictory to what a family court has decided in terms of a custody arrangement. So ideally for a guardianship, you're going to have this discussion ahead of time. We need to have an understanding of if we have divorced parents, that they are going to be able to work together amicably to make decisions. Because if there are co-guardians, the requirement under the statute is that those co-guardians make unanimous decisions. It's not that when daughter is with mom as the guardian and when daughter is with dad as the guardian. No, the court for a guardianship has to make sure that mom and dad are making medical decisions together, that they
Okay.
are deciding on where the child is going to live together. And so again, person-centered more than anything here.
Right.
So what happens is if mom and dad do not get along, if there is conflict, one of them could concede all of this decision-making authority to the other. Sometimes that is the settlement or decision that we come to. And that's not if dad says, okay, mom, you can be the guardian, that doesn't mean he's no longer dad. And it doesn't change his parental rights under the family court.
Sure. Okay.
But if we do have a conflict between the two parents and they do not get along, with this person-centered approach that the court takes, it is entirely possible and it is within their purview to say, neither of you are going to be the guardian. We're going to find a neutral person because it's this court's responsibility to act in the best interest of this 18-year-old or of this adult and find the most suitable guardian for them.
But one parent could decide to opt out, just if they were both in agreement. I don't want to take this role, you take it. And so they don't both have to. So that's
That's
clear. Okay.
correct. And we do
That's
have
good.
cases like that. But what the
Okay.
court wants in that scenario is they want an affirmative consent from that parent who is declining
Ah,
the
but they're giving it
responsibility.
up.
That makes
Yeah.
sense. Yeah. So it can get a little bit more nuanced when you have divorced parents coming into your office.
Absolutely.
So I should probably start saving money right now.
Hence the range of complexity, right? It's not a one size fits all.
Yeah,
That's right.
exactly.
So thank you. Thank you, Joe, because I think what we wanted to really get through was to have helpful insight, tips, and tricks. And I think you've given us several discussion points so that people can sort of not be surprised as what to look forward to. And I think we've hit our goal of trying to really reach that today. So thank you. Thank you so much.
Thank you. If you liked today's topic or have comments, questions, or thoughts on what else you would like us to cover, please visit rarelyfamiliar.com or connect with us on all the social channels. Resources will be listed in our show notes, and we'll be back next time with another discussion around living life successfully with rare medical complexities. Thanks for joining us on the journey.